while we've been talking, I've just asked ChatGPT to reformat it into a court-ready declaration, which I am signed.
Frankly, presents a suspicion that it may itself be an AI-generated video. There needs to be evidence of who recorded the video. Those complaints are simply those of a dissatisfied litigant.
You're going to get a judicial complaint against you now.
This is Chris Martin. He's a judge in Zandt County, Texas, a county of about 60,000 people less than an hour east of the Dallas-Fort Worth Metroplex. This man, Barney Donaldson, does business as a ministry that sought to convert a former nursing home into a residential living facility. He's been locked in litigation with the City of Canton for years over that property. In the meantime, Donaldson says he received a video that demonstrates Judge Martin's bias. He even submitted a ChatGPT-generated report asserting the video is authentic. So why did he wait 2 years to bring it up? Let's Warners.
We're here on the plaintiff's motion to recuse Judge Martin. Are the parties ready to proceed?
This is Joe Alfred Eisen Jr., who will be representing Mr. Donaldson for this hearing, this recusal hearing. I understand Mr. Donaldson has signed in. He signed in. We're ready to proceed.
My name is Alfonso Charles. I'm the presiding judge of the 10th Administrative Judicial Region, and I've assigned myself to hear this case. I do see that there was a motion, pro se motion filed by Mr. Donaldson asking me to reconsider my appointment. And it does, in that motion, it says that it is not a motion to recuse, and I'm going to deny that relief. I'm going to hear this. I have assigned myself. I am familiar with the parties and many of the accusations, so I think judicial economy dictates me hearing this.
There are 3 paragraphs that specifically address the video, I believe, that Mr. Eisen is getting ready to play. There are 2 attachments. Attachment 13 to the declaration is the actual video, and attachment 14 is some kind of report that is presumably presented as some sort of authentication to it.
In light of Mr. Voss's opening statement, I request that Mr. Donaldson, who's online now, play for us the video.
Are y'all able to see that?
I can see it.
I'm not, but I'll take everybody else's word for it.
Okay. There is no audio.
Mr. Donaldson's still out in the hallway. Go have a deputy rough him up a bit. Maybe he'll go away.
Were y'all able to hear it that time?
Yes.
Yes.
I request one more play, and then I will proceed to questioning.
Mr. Donaldson's still out in the hallway. Go have a deputy rough him up a bit. Maybe he'll go away.
Mr. Donaldson, did you just play an electronic recording that it contained a video and an audible portion of sound?
Yes, sir.
Where did you obtain this video?
Sent to me through Facebook Messenger from a man named Rusty LaFleur.
And how did you obtain Rusty Fleur's name from Facebook or from some other source?
It came to me through a messaging service. It's like text messaging. It's not directly on social media, but it's part of social media. I have tried to respond to him, and the account it says no longer available on Messenger. The account does no longer exist.
This video was uploaded to you. You received it on your phone or the date it first came into your possession. What date this video was actually taken?
I uploaded it into a software called ChatGPT for analyzation, telling me everything it could extract from it. And it determined that it was recorded on an Android phone on May 21st, 2021.
As far as this video is concerned, did you suffer personal injuries from handling, we'll call it, by sheriff's deputies in the courthouse in Van Zandt County.
Yes.
Did you file suit in federal court about those injuries?
Yes.
Now, since that date, you have continued to litigate cases in Van Zandt County. Is that correct?
That's correct.
Do you feel like you have an unbiased judge or court determining your cases since May 2021?
I do not feel like I've ever had an unbiased judge when dealing with Chris Martin.
But you intend or have filed complaint against Judge Martin for official oppression, I should say.
I have sent everything, including the declaration, to the Texas Rangers, to the Texas Attorney General, and to Van Zandt County DA Tonda Curry.
Now, as far as this case is concerned, if this recusal motion is not granted, you're in the process of having more things ruled on by Judge Martin. Is that correct?
That's correct.
Now, specifically, they're going to rule on a motion that you're a frivolous litigant without any hearing at all, just under submission. Is that correct?
Yes. Yes.
I rest my evidence, but I'll offer the video.
At this time, Judge, then I'm going to lodge my objection to the video. The city objects to this purported video because it lacks adequate foundation and does not accurately portray the situation depicted. The city also objects to attachment number 14, which is the ChatGPT document as a purported report. There's no name, there's no credentials, it's unsigned, it's unsworn, and itself admits that it is not a court-ready exhibit on the second page. Video presents a suspicion that it may itself be an AI-generated video, at least in our mind. There needs to be evidence of who recorded the video, where it was recorded, when it was recorded, how it was recorded, etc. And lastly, that there needs to be evidence that the video is an accurate portrayal of events as they were existing on the date and time presented.
All right. I don't remember the question, but while we've been talking, I have just asked ChatGPT to reformat it into a court-ready declaration, which I am signing.
Let me handle this, Judge, if you will. We may be able to submit that later, Mr. Donaldson, but we're in a hearing right now, and I need to proceed with 2 questions on you, and then I need to proceed with the argument. Have you been in front of Judge Martin many times and heard him make rulings?
I have.
Can you compare the voice on this tape, the audible portion, and state whether or not you're familiar enough with Judge Martin's voice to tell us whether that's Judge Martin's voice, as you remember?
Yes, it is.
That's all the questions I have. Now I'll move to my argument. This is a recusal hearing, and the question here is impropriety. And if there's any ambiguity at all in this evidence, the court must lean toward granting the recusal and preserving public confidence. Go ahead. Ignore this video evidence. It's not going to go away. You can assign yourself all you want, but this video is going to remain. And not only that, the audible portion is going to remain. And we've been dealing with video about 20, 30 years in my 48 years, but we've also been dealing with sound recordings much longer than that. And so this video, if it was just a tape that was put forth, there's enough evidence here to admit it from our standpoint. And here we have proof, if it's true, of horrible things that have occurred. Sickening. It sickens this attorney. As we say, grant our motion for discovery, rule on Mr. Voss's and Mr. Ritter's objection later. Let them have their crack at it with their city experts. Maybe they can gender up the fact that somebody spent an enormous amount of money to make this video in order to try to embarrass Judge Martin.
I am going to sustain the objection. This video has not been authenticated under the rules of evidence and under the established case law. There is nothing to show that it is authentic. The person who made the recording has not testified. And there is, in this day and age, there's nothing to show that it is not AI generated. So therefore, at this time, I am going to sustain the objection as to the video. You may proceed with your argument.
Well, I don't have much more argument on that. I would again stress that the court should not have reassigned itself to this matter. I know in the past, the record will show by judicial notice of the cases that you've sat on. You've done this numerous times with Judge Martin. And we believe that we ask this question, you allow Judge Martin to continue in this. Is this evidence of impropriety enough to undermine public confidence? The answer is indubitably yes.
Let me ask this question. All right, Mr. Donaldson testified he's had possession of this since 2023. There have been three other, I'll take judicial notice of three other recusal hearings that I have heard from Mr. Donaldson involving Judge Martin since that time. I heard one on April 23rd, 2025. I heard one on May 17th, 2024. My question is, if Mr. Donaldson has had possession of this videotape or this video since 2023, how is this even timely filed when he obviously knew about it when he filed this new lawsuit?
That's now, you finished?
Hang on. Let me finish.
Go ahead.
It was never brought up in the other two recusal hearings. So how is this even timely filed, and how is this issue not waived?
How? Well, in the first place, under canons of judicial ethics, you shouldn't be arguing this case for the other side. You gave a perfect argument for Mr. Voss that he didn't make.
No,
And so
Mr.
thank
Eisen,
you for
I have
representing the
Mr.
other
Eisen.
side in this case. And
Mr.
we object
Eisen,
to that. But the comment on that is Mr. Donaldson, number one, is not an attorney. Mr. Donaldson, number two, is ignorant of the laws, and so is Mr. Birnbaum. Answer is number three. When I was requested to take this case and this came to my attention, I am presenting it. So blame me because I made my appearance now on this recusal. I had my other appearance in this recusal, another one you reassigned yourself to, and I didn't bring it up then. I didn't know about it then. So that's the answer to your question.
There was a lack of evidence to show that Judge Martin has created a condition of, or a question of impartiality by his actions. There is no evidence to support that. The only evidence that has been presented, besides the video that has been not admitted into evidence, are Donaldson's complaints with the court's rulings in the underlying cases. And I submit that those complaints are simply those of a dissatisfied litigant and not someone that is able to show that there's some sort of improper bias or prejudice by Judge Martin.
We again lodge your objection for this judge sitting on this recusal to represent the opposing counsel, represent the opposing side, attempt to construct a waiver out of the evidence. It's totally improper. It's itself grounds for recusal. But that's a matter for another day. And I state that we again stress you should not make any ruling until there's discovery, because I have this sneaking suspicion that this, like all this other whistleblower evidence, it's going to be proven to be authentic. And then all those that tried to cover it up will have to be answering a lot of questions. My client has requested that I make an oral motion to recuse, Your Honor, from making this recusal ruling.
An oral motion to recuse is the equivalent of no motion at all, and I'm not going to recuse myself. I have heard the testimony, reviewed the motions, the responses. Court makes the following findings in ruling. The main piece of evidence was the video. The court has found that the video, that it in itself was not admissible because it was not properly authenticated. Even if it was authenticated, the time for filing a motion to recuse, it must be filed as soon as practicable after the movement knows of the grounds stated in the motion. Mr. Donaldson testified he's known of this video since 2023. There have been other cases that he has filed, motions to recuse, that he never brought this forward. If this was proper grounds for recusal when he filed his original lawsuit, in this case, he could have filed a motion to recuse. But this motion to recuse was not filed until January 26th of this year. Court finds that even if the video was admissible, that the motion was not, that issue was not timely filed. Therefore, at this time, I am going to deny the motion to recuse.
No. We need a ruling on the discovery also, Your Honor.
I find that there was no need for additional discovery in this case. Further, that motion for discovery was not filed until a few hours before this hearing was scheduled, this hearing was to be heard. And so therefore, I denied that motion for.
So again, you're practicing law. You are attempting to represent the city. They never made these arguments. We object to that. Thank you for your ruling.
You're welcome, Mr. Eisen. I'm not going to engage. Nothing further. We are adjourned. This hearing's over.
Good.
Your Honor,
Thank you.
Your Honor, may
Yes.
I briefly put something on the record?
You may, Mr. Rip.
I need to put this on the record that Mr. Donaldson messaged me directly at 12:14 with the following. I am not going away until my personal property is returned and I'm either given back the real property I paid for or paid for it. You block me out of the courts and leave me with no remedy, then I will be under duress and have additional rights under common law. Remember that. I see you making faces. Feel the need to preserve that on the record for any future, for possible future events.
This point, this hearing is over. There's
Thank
nothing
you.
further. We are
Thank you, Your Honor.
adjourned.
Your little ass is in this up to its neck, Charles. You're going to get a judicial complaint against you now for representing the other side.
Joe, they're still here recording this.